Hello, justice seekers. Chris Fabricant is the Innocence Project's Director of Strategic Litigation, one of the foremost experts on forensic sciences and the U.S. criminal justice system. He's also the author of the new book, Junk Science and the American Criminal Justice System. Chris, thank you so much for the time. How are you doing today?
I'm doing great. Thanks so much for having me on.
It's my pleasure, Chris. So what was your goal with this book?
I was really trying to create, a new genre of untrue crime or not true crime genre, and to dispel some of the myths around the use of forensic sciences in the United States, and also to have an understanding for the general public of really what it's like to litigate in cases and in courtrooms around the country that few folks have ever been to, and like deep in the deep South, in places like Mississippi and in Texas and in the middle of the country, and also places like New York City, where the use of forensic sciences is misunderstood and misused every day, but not in the ways that it's depicted in shows like CSI or Forensic Files or any of these others, is the actual reality of innocent people being put in prison based on subjective speculation masquerading as scientific evidence. And so much of the American public, including lawyers, are scientifically illiterate, and the consequences have been really, really dramatic. And nearly half of all wrongful convictions are attributable, at least in part, to the use of unreliable forensic evidence, which is astonishing. You think about it, because science is what we rely on. This is what mankind uses to advance our knowledge of the world around us. And for science, or purported science, to have contributed to so many miscarriages of justice, centuries of wrongful imprisonment, is really just an astonishing scandal that few really understood, and understand in the way that, Innocence Project lawyers do, and people who do this type of work. So I wanted to write a book that, was a good read, that tells a lot of stories, and that will hold interest of people that have no interest in science, but have an interest in the criminal justice system. So that was really my goal.
Bunch of heartbreaking stories too at that. Now, some of these supposed sciences that you can poke a bunch of holes in when you really actually look at the true science of things, you have labeled in this book the title of the book, and that is Junk Science. What is the birth of junk science as a sort of jury swaying piece of evidence in the U.S. criminal justice system?
Well, people have been using, claims that they're, science-backed, in various forms of fraud and malfeasance for as long as there have been science. But in the criminal justice system, really, it became, the forensic sciences and the forensic scientist that we know today, it was really in the post-World War II era. And with the establishment of the FBI crime lab, and then that led to also a lot of local crime labs going online and starting to do more of traditional forensic techniques like handwriting and shoe prints and fingerprint analysis, and sometimes what's called ballistics or firearms and tool mark evidence, and that kind of forensic techniques. And before that, there wasn't really an established field of forensic sciences, in that there weren't board certifying entities to certify people. Like a forensic pathologist, for example, was not a profession that had a board certifying entity until after World War II. And what it became as, this mix of both popular culture being, moving from radio to television, and the criminal justice system becoming part of popular culture in this way that it became entertainment. And so the Sam Shepard trial, which I talk a little bit about in my book, was the first really, lurid media sensation, and it involved a lot of forensic sciences, because like all circumstantial evidence cases, you need, alleged scientific evidence to place the suspect at a crime scene. And as a result of that trial and others that were less prominent, is that forensic pathologists became stars, and forensic science became a field that you could aspire to be. And the problem really is that it wasn't associated with mainstream science. It was this kind of other science that was forensics. And so the techniques were not being researched in laboratories, but they were being developed in crime scenes, often by police investigators, to solve a particular crime. and without doing the scientific validation research that needed to happen before this evidence, or so-called evidence, was being used in criminal courts. And so during this era, during the buildup of both the sides of the legal system, the criminal and the civil side, resulted in explosion of our legal system around the country. Became a huge institution, both on the civil side as a result of a lot of personal injury litigation that became much more prominent in the 70s, and product liability and mass torts. And that type of litigation became, exploded during that same era. And on the criminal side, mass incarceration and the drug war, led to an explosion of the size on the criminal justice system. And as a result, cottage industries kind of sprung up to support this system. And one of those was expert witnesses. As we use more and more science, expert witness became a profession that you could do, you didn't have to have any other fields. You could just work as an expert witness. And so many forensic techniques and forensic experts became incentivized to work toward becoming an expert in a field and become an expert witness. And probably the most, the example that I focus on a lot in the book is bite mark evidence. And you could see the evolution, which was, I have spent a lot of time litigating these cases, but I hadn't actually saw how it came online for the first part. And so what happened is that the forensic pathologists were working next to, shoulder to shoulder, with forensic dentists. And so if you're familiar with, where somebody, a body has been burned beyond recognition, right? And that, that they were only able to identify this person through their dental records. And most people don't realize that that's a forensic dentist, your local neighborhood forensic dentist that did that work, or a forensic odontologist, as they say in court, which is the same thing. But they weren't actually becoming stars. They weren't testifying in court. They weren't identifying suspects. They weren't really forensic scientists. They were working kind of adjacent to the field. And so they started pointing to bite mark evidence as something that could be theirs, right? So dentists, we know teeth, and so we should know bite marks. We identify bodies. And so they just kind of invented this new field. And the founding fathers of what became known as the American Board of Forensic Odontology invented their credentials. They started certifying each other, and they became board certified forensic odontologists, and they were looking for a bite mark case. And when they finally found one, the perfect case in a lot of different ways, and I kind of explain why in the book, but really it was a gruesome murder of a landlady, and that we had good reason to believe that the suspect had done this, but there was really little evidence to point to him, little hard evidence beyond suspicion. And so these founding fathers, found a bite mark on the victim's nose, which is in cartilage, which doesn't have the same problems of retaining any information that skin does. And one of them had a law degree, and so understood the value of legal precedent. And so it was important to get it right the first time. And then that was Walter Marks, the first prosecution in Southern California that led to the first use of this evidence. And it sounded like it was already part of forensics, right? Because they had credentials already. They had been working in the mortuary right next to forensic pathologists. They had, they were members of the American Academy of Forensic Sciences, all this other stuff. So the idea that they were promoting junk science was farthest thing from anybody's mind. And it had this superficial appeal that you would, be able to eyeball evidence and say that there was a match. And as a result of that first case, the legal precedent has spread like a virus around the country and led to centuries of wrongful conviction just based on bite mark evidence. And then, when one of the stories I tell in the book is the Ted Bundy case. Mm-hmm. And that was like kind of the next, crime of the century, and trial. And it was the first nationally televised trial in our nation's history. And from researching it, I was really surprised to learn this. And I didn't know it when I went into to write about, how, this evidence became so mainstream, is that they had really almost no actual evidence against Ted Bundy for the first murders he was convicted of, the Chi in the Chi Omega killings in Florida State University. Is that there was a really shaky eyewitness ID from Nita Neary, who would have identified somebody else under hypnosis. And really, that was it. He was in the area. I'm not doubting his guilt, what I mean? But what they needed was something like a bite mark. And so they found one on one of the victims. And then these founding fathers, the same people who had snuck bite marks into court the first time, became national celebrities because they were testified in court in front of millions of people and matched Ted Bundy to that injury. And then Ted Bundy was conducting cross examinations himself. So it became something of a circus. And after that, they were just off to the races. And all of that a single piece of research that demonstrated the claimed abilities of these dentists to do anything that they claim to be able to do.
Yeah, it was very eye-opening to read about in this book regarding Ted Bundy. Now, junk science relies on case studies published in peer-reviewed journals. While that sounds impressive on its face, why is it not that impressive ultimately, Chris?
Peer review is something that is widely misunderstood in science generally, and certainly in forensic sciences, in that the journals are often, what peer reviewed. And so what that typically means is that it's a blind submission from a scientist that's publishing the results of a piece of scientific research that is evaluated by other scientists in the field, critically evaluated, looking for flaws and methodological flaws and conclusions that aren't supported by the data, and those types of potential issues with a piece of literature, and often giving feedback and then resubmitting or sometimes rejecting. And when it's published in a peer-reviewed or a referee journal or something like that, there's some assurance that it's been through a rigorous process and that the data say what the literature is claiming that it does, right? And so that's, very reductive, but that's basically what peer review is. And a publication in a peer-reviewed journal like that is what folks are typically thinking about when they say, well, this has been peer-reviewed in the literature, so it's good to go. And what happens a lot with forensics, and something that I think that you're asking about from the book, is this notion of case studies. And what case studies are is that how a particular forensic technique was used to solve a particular crime. And by solve, and your listeners can't see the air quotes that I just used, but, as the Innocence Project works, has demonstrated for a long time, is that, a jury verdict doesn't mean that the crime was solved. It means that there was a jury verdict. So this was true with like the first case of bite mark evidence. That dentist wrote a peer-reviewed, publication that was published in a peer-reviewed journal, the Journal of Forensic Sciences. But it was just an explanation as to how, they'd gone about solving this crime and what techniques they had used. It wasn't actual research. It was a story. And what happens with case studies, which are legion in forensic sciences, is that you have these titles that really say or claim that, hey, I validated bite mark evidence. There's a peer-reviewed publication that claims to have proven the uniqueness of the human dentition, and it uses the phrase "to a reasonable doubt." And it was done by some Vegas dentist who's responsible for Ray Krohn's wrongful conviction, who sent him to death row in Arizona. That piece of literature was published in a peer-reviewed journal, but it wasn't peer-reviewed because it wasn't blind and the methodological flaws weren't actually identified. And so you'll just get lists of literature that suggests that there's been a lot of research done to support the claims, but few lawyers ever actually read the literature. And when you do, and as part of my job, I have to, you're astonished at how little they say, or the claims, the leaps of logic that are made from tiny little insignificant studies to claim, something as groundbreaking as proving the uniqueness of the human dentition. So it's deeply flawed. And this is not true. I mean, this is true with lots of sciences, but forensic sciences are the worst offender in my view.
Who was Cameron Todd Willingham, and how was his prosecution tainted by junk science? And I have to admit, this is one of the stories in this book that got to me the most as the father of two young children.
Yeah, Cameron Todd Willingham is, many of your Austin listeners will be potentially familiar with the case of the wrongful execution of Cameron Todd Willingham for the arson murder of his three young daughters. And there was the only evidence that was used to prove, and I'll use air quotes or again, his guilt in that case was folklore, pure folklore that had been passed down from generation of fire inspectors that that they believed demonstrated that this was a deliberate fire. So they had many different um, arson indicators is what they would call them, and so there were things like alligatoring on the floor, or pour patterns, right? And so that was believed to show that a liquid accelerant like gasoline or lighter fluid had been used because of the patterns on the floor suggested that. There was evidence that tended to show that there were multiple points of origin of the fire, right? Which makes it, almost impossible to have been set accidentally, right? It looks like it's set deliberately if it's being set in multiple places. There was shattered glass or crazed glass, which was thought to be as a product of the use of an accelerant too, because it was believed that fires burned hotter if they were fueled by accelerants. And there were all these like indicators that turned what was a terrible tragedy into compounded a terrible tragedy. Three young girls were killed in an accidental fire, and then their father was executed wrongfully for deliberately murdering them. And what's, I, point out in the book and discuss is that there was a parallel case in Texas that at the same time that, based on the same arson indicators, they were in fact jailed together. They were on death row together. The Cameron Todd Willingham and Willis is the other. And that the only real difference between those two cases is the level of representation that one of the or not a co-defendant, but the parallel case it had, and was finally exonerated right around the time that Cameron Todd Willingham was put to death. And it was really, what was astonishing when I was looking at it was that there was, the science had been debunked before Cameron Todd Willingham was actually executed. There was a fax from Gerald Hurst, Dr. Gerald Hurst, who was a very, very prominent Oxford-educated scientist that knew that this was junk science that had been introduced at trial, and faxed that to Governor Rick Perry was at the time, who did nothing, and the execution went forward. And then I outlined, what happened with the Texas Forensic Science Commission hearings after the execution, when there was an effort to really uncover what a lot of people believed even back then was an innocent man being put to death. And Governor Perry shut down what Barry Scheck called like a Saturday Night Massacre, was that he shut down the commission and fired its head before they could actually come to the conclusions that might have damaged his reelection chances. So, and it wasn't until after the election was over that the Texas Forensic Science Commission issued its report and found, exactly what I'm telling you right now, is that there was no basis to conclude the science that was offered. There was no basis to conclude that this was a deliberately set fire. And, what's astonishing about that case and arson, investigation in general is that after they finally did scientific experiments and discovered that all of these indicators that they believed demonstrated deliberate fires were in fact the product of what's known as full room involvement. And that's what, or flashover, it's called, is that when it's been described as the difference between a fire in a room and a room on fire, is that you would get things like alligator on the floor and crazed glass and indicators that seemed to show that there were multiple points of origin. And it was actually debris falling from the ceiling, right? Creating what looked to be multiple points of origin. So all of these indicators that were used in Cameron Todd Willingham's cases and many others were falsified through scientific experiments. That's what scientific experiments are supposed to do. You have a hypothesis and you see if you can falsify it, but it wasn't done till after an innocent person had been executed, and probably not the only one. And, after when finally the science was debunked, the number of reported arson incidents in the United States dropped something like 40%. And that wasn't because we have fewer arsonists, right? It's because they weren't using junk science anymore.
Mm. How is the 1993 Supreme Court ruling involving Morel Dow Pharmaceuticals an important moment in the slow awakening to the true value of junk science, Chris?
We talked earlier about the civil legal system and the criminal legal system, and how both sides of our legal system really grew exponentially during the 70s and the 80s as a result of personal injury litigation on the civil side and mass incarceration on the criminal side. On the civil side, a lot of those class action lawsuits and some of the other litigation, product liability and mass torts litigation that had been successful by plaintiffs' attorneys, a lot of it was based on subjective speculation, that there wasn't real science behind that. A lot of it was good stuff too. Ford Pintos were taken off the market and some dangerous products were removed. So I'm not suggesting that this was all junk, but there were, plenty of very questionable verdicts that were based on very questionable science. And so corporate America, had had enough, and they were seeking a new rule that would be a more rigorous test of purportedly scientific evidence before it'd be introduced at trial. So they teed up a case called Daubert, and I know people who know the Dauberts, even though it looks like it should be Daubert, it's actually Daubert. That's the way they pronounce it. But so this was a lawsuit that was related to the use of a drug called Benetine that was a prenatal medication to prevent morning sickness, and it was believed to cause birth defects. So that case went to the Supreme Court, and the Supreme Court overturned really a century of, well, I don't know if we want to call it precedent, this tradition of what was called a Fry test, and they created a new test that turned put the onus on excluding unreliable evidence on the judges. It used to be that the judges would defer to the scientific community and ask the question, is this technique generally accepted in the relevant scientific community? And so they would essentially count noses. They wouldn't have any independent judgment on the scientific bona fides of a particular technique. The problem with that was the way that they defined the relevant scientific community, and particularly in forensics, was often the experts themselves, the people who made their living, testifying as expert witnesses in this field, right? So if you ask somebody who's living, depends on the continued acceptance of this technique, the answer, if it's generally accepted or not, is going to be very obvious, right? Of course it is. If you'd ask mainstream scientists about so many of the techniques that I write about in my book, even back then, they would have said, no, there's no scientific literature supporting this, right? But that was the rule. That was the Fry rule. It was one that allowed a lot of these techniques into court to begin with. So the Supreme Court case, Daubert, there was an effort to change this rule and put the onus on the judges to say, no, you have to do some independent research. You have to examine the claims. And they won. And the Supreme Court handed down this ruling that laid out 5 factors that are, reflect basic scientific principles that a judge is supposed to consider before they allow so-called scientific evidence into trials. And what was astonishing was that it worked on the civil side, and that judges began excluding unreliable evidence at rates they had never before done, right? And they took that responsibility seriously. On the criminal side, nothing changed. Literally nothing changed. There is an empirical study done by Peter Neufeld, the co-founder of the Innocence Project, about 10 years after Daubert, that showed that empirically, that prosecutors were always successful in getting in whatever kind of evidence they want. The defense had virtually never successfully excluded a prosecution proffer, even on techniques that we know had led to wrongful convictions, were still being allowed into evidence. So this theme that I've explored around that in my book is what I called it poor people science, right? And that's what you get in the criminal legal system is poor people science, because it's plain, and the empirical evidence demonstrates it, that we don't care about the rigor that behind so many of the forensic techniques that are used in our justice system. I did a follow-up study with Brandon Garrett in 2018 that showed that there had been really nothing had changed. And, it's for this reason that the Innocence Project really advocates for something like an FDA type agency to do the validation research outside of the criminal justice system, because within that adversarial process and given the biases against criminal defendants, that separating sense from nonsense is really almost impossible to do. And we do with consumer products like toothpaste or aspirin or toilet paper or whatever, that before they're used on the public or that for public consumption, that they're tested to make sure that they're safe. We have nothing like that for forensic sciences. And though you can be sent to death row on some, alleged scientific evidence that's never been subject to even the most rudimentary scrutiny, the only thing standing between, that type of wrongful conviction is, and adjunct science, is a judge. And the judge is not going to rely on scientific literature. The judge is going to rely on legal precedent, right? And legal precedent doesn't change, not very much. And science is always changing. It's always moving forward. So that inherent tension makes it almost impossible to continue to use scientific evidence if we can't acknowledge that science changes and that what we know today, we may not be as sure about tomorrow.
Was part of the problem here also in the wake of this ruling that a lot of folks who are complicit in this system know exactly how their bread is buttered and they didn't want to rock the boat too much in that regard?
Yeah, one of the status quo is a very, very challenging thing to challenge, right? And what I think, as far as the individuals involved in forensics, the individual experts, in some of these agencies, is that they, by and large, are well-intentioned, smart, capable, and not seeking to frame innocent people, right? For crimes they didn't commit. I don't believe and with notable exceptions, some of whom I write about in my book, but for the most part, are not seeking to do any harm. They're seeking to bust bad guys. And that mindset, though, is a real problem for science. If you talk about, the National Academy of Sciences 2009 report, which is the most prestigious scientific entity certainly in this country and maybe the world, one of the fundamental recommendations that they made was separating crime labs from law enforcement. And it's really, really important because of how much the mindset that I just talked about and how subjective these techniques are. And if you have subjectivity, it's going to be prone to bias. And this is not deliberate. It's not racism. It's implicit bias, or sometimes known as, cognitive bias. And this is, the influence of irrelevant information on final conclusions and forensic analysis that have nothing to do with the actual technique at issue, right? There's things like somebody confessed or that there was an eyewitness or something like that. So that shouldn't matter to a fingerprint examiner, but it does. And I write about one of the really amazing experiments that was done in fingerprint analysis as relates to this, and where they took 5 latent fingerprint examiners who had at least 20 years of experience. They're board certified. And I think one of them was from the FBI. And there was an experiment done to see whether or not contextual information would influence their conclusions. And so Dr. E.T.L. Dror is a neuroscientist in the UK, conducted an experiment where he sent these experts casework, so a latent print from a crime scene and exemplars of potential suspects. And what he didn't tell them was that it was from their own prior casework. They had already done, and come to conclusions on this. And the only thing that he changed was the contextual information that was irrelevant to it, right? So something like there was a witness or there was confession or whatever, right? That had nothing to do with the evidence. And 3/5 of them changed their original conclusion based only on irrelevant contextual information. Nothing had changed about the fingerprints. It was just the information. So the idea that we, can continue to have, forensic sciences just as an arm of law enforcement and pretend like this is going to be unbiased, objective science is just wrong.
So I'm glad you mentioned what the National Academy of Sciences did. You just talked about bias. It was in 2006 that the NAS put the most commonly used forensics in the criminal justice system under the figurative and literal microscope, Chris. This included bite marks, microscopic hair composition, arson science, and then, of course, bias as well. What do they find about microscopic hair comparison?
I'll paraphrase here that it's junk, right? Is like what they found is that really two things, and if you think about it, this is true with all of the trace evidence that we just talked about, right? And we talk about fingerprints, talk about ballistics or firearms and tool marks or bite marks or tire treads or all these kind of trace evidence or pattern matching techniques, is that they rest on two assumptions, right? Is that one is that you can make a match, right? You can declare these two things, identical, right? And then the second thing is like, so these two hairs, let's say, right? These two hairs are identical, they match. This one I found at the crime scene, this one I plucked from the suspect's head. I see no differences between these under the microscope. It's like, okay, let's say for a second that you can do that, right? Then the second question is really, so what? How many other people might also match, right? Is it 1 in 5 or 1 in 5 million, right? So we don't have that information. And what the NAS pointed out is even making a match, there's no agreement on what microscopic characteristics must match and how many of them must match to even declare a match, right? It's just somebody eyeballing the evidence and saying, I see these two things as identical. And then to be able to have any information as to the so what part, right? How probative is that match? You have to know how rare or how common that, those variables that you're matching together actually are. And we don't have that information either, right? So you can't say that, this hair or 1 in 5 hairs would match, this hair. And you can't say, even if you could do that, you can't say that there wouldn't be millions of other people that would also match that hair. Nevertheless, courts had accepted and FBI special agents had proffered, and they trained states experts to give testimony matching hairs and declaring that it was the suspect's hair, or was almost, impossible that it would be somebody else's hair, or was very, very likely to be that person's hair for a century. And I write, like, my first week here at the Innocence Project, is the biggest scandal in forensic sciences in our nation's history was unfolding at the time, and was the FBI was admitting, after over 70 wrongful convictions attributable at least in part to the use of hair comparison evidence, that the evidence had been grossly overstated for 100 years. And that they joined the Innocence Project and the National Association of Criminal Defense Lawyers to conduct an audit of thousands of cases to see how many other miscarriages of justice that were there. And that was the critique that the FBI adopted, was the same critique that the NAS report, had offered years before. And it was just like there was another 3 wrongful convictions in DC, back to back to back, that were reported relentlessly by the Washington Post, a reporter named Spencer Sue. And those particular cases also were all Black men. They were all convicted of assaulting white women. They were all based on microscopic hair comparison, was very important to it. There were 3 different experts, so that was important, so you couldn't make the bad apple argument. They were all from the vaunted FBI crime lab. And what was worse about hair microscopy is like that we know that structural racism plays, the central role in mass incarceration.
Mm-hmm.
And this type of evidence could also be used to racialize the testimony, particularly when it's a Black man accused of assaulting a white woman. And the so-called expert testimony is saying that they found a so-called negroid hair on this white victim's hair, or on this white victim's body, has the effect, under the guise of scientific evidence, of putting a racial charged tinge into the prosecution. So it's all the more prejudicial than in ways that, beyond, traditional, unfair prejudice. So all those factors kind of finally got the FBI to the table and to do this, what I call the junk science recall in the book. But, the principles about, what information you need to make a match and what information you need to state how, the so what question, the how probative is the match, that's true for fingerprints, that's true for firearms, that's true for all these forensic techniques. But I should say something about fingerprints because, like you, I believe, probably like you, that fingerprints are likely to be unique. What Which is not really, it's not a scientifically validated fact, but it's also not really the issue in forensics, because what you have with fingerprints is often smudges at crime scenes, not very much information. And we don't know how much information you need to say that that's enough information that you could say that it only come from that one person. And what we also don't know is how similar fingerprints might appear. And so
Especially when
that's
you're talking to partial prints, correct?
right, exactly. That's what I meant by latent prints. But
Oh,
yes,
my
partial.
apologies. Yes.
No, but that's you're right to clarify. So it's a partial print at a crime scene, and so that is a different problem than some of the other issues that I've been talking about. But it is a problem. So fingerprints, while generally very reliable, the reliability really depends on the quality of the evidence, and we don't have standards for how much information, how high quality that we need before we can make a reliable conclusion.
Yeah, I'm glad you mentioned the fingerprints. I was going to ask you about. That's one of those things in this book that maybe blew me away as much as anything, because like you said, we've been led to believe our entire lives because all fingerprints, when you're looking at its entirety, are like snowflakes, that everyone is different. That's taking the entirety of the fingerprint, and oftentimes what you're looking at is something significantly less than the entirety of the print itself.
Right. Yeah. I mean, and that's what, it's that conflation of, like, when people think of, where we used to open our iPhones using our fingerprints, right? And if we get our kids fingerprinted so we can identify them, right? So that's the same kind of mythology that we talk about, that I was trying to debunk with the book, right? Is that this uniqueness of everything, right? Snowflakes aren't unique, by the way, right? The is like, so let's
I didn't
start
know
there,
that, so
right?
thank you there.
The is like that we just assume uniqueness of everything. People assume the uniqueness of the human dentition, of fingerprints, of hair, of all these other things that you actually have to do scientific research to show that. And also, it's like, how much magnification do you need? How much of a granular look do you need of, like, your teeth to declare them unique, right? So if you examine anything closely enough, probably it's going to have be either unique or very highly distinct. But that's not the level of examination that typically goes into a forensic matching, assay.
Yeah, back to the NAS debunking forensic sciences, certain forensic sciences in 2006 for a sec. Why did the discovery process for arson junk science have to be done differently? And what was ultimately learned there?
Well, arson, it was very few forensic techniques can point to one experiment and one case as a turning point, really, for the entire field, and as quite as dramatically as arson evidence. And this is a story that I wrote about, the Gerald Lewis case, in the book. And the NAS, when they took John Lentini's testimony and did that research, that experiment had been done. It shouldn't have even needed the NAS by that time to do it, because of the experiment that was known as the Lime Street experiment. And what happened there was that Gerald Lewis was going through a divorce with his wife, a contentious divorce, and there had been allegations of physical abuse in the past, and she had thrown him out of the house the night before the house that he'd been thrown out of burned to the ground, and 6 people died. So there was a lot of, and he was there at the time, and was there when the fire department finally showed up for this, enormous inferno that killed his entire family, except for his one surviving son. And so he was indicted for capital murder. And there was an outcry for vengeance in the local community there, and there was the same arson indicators that we talked about as related to Cameron Todd Willingham and to a couple of the other arson cases that I talk about in the book, were observed in the aftermath of this terrible tragedy, and that led to the indictment. And what happened with Gerald Lewis's case is that one is that he got very experienced defense attorneys who had previously litigated an arson case and sent investigators immediately to the scene to conduct their own investigation. And then they offered a lot of evidence of innocence that these investigators uncovered that confirmed some of the aspects of Gerald Lewis's story, that he had tried to help put out the fire and what was going on inside the house when he ran in to try to rescue one of the kids. And there was, a weakening of the prosecution theory. But what they had left was the folklore of arson. And what you see, which was really an incredibly brave and unusual move by the prosecutor in this case, is that he allowed John Lantini and another fire investigator to conduct an experiment to test the defense's theory in the case that this had been accidental. And just fortunately, and this was, kind of a marginalized neighborhood, and there happened to be an abandoned house next door to the house that had burned down that was identical construction. And they reconstructed, everything about the original interior of the house that had burned down. They found the original, a replica of the couch that was in there. They put up new drywall to match the drywall that had been used in that house. They replicated the ventilation systems, everything down to as much, and spent, tens of thousands of dollars on this project. And then they lit a match and they saw what happened. And what happened is when they finally learned about full room involvement or flashover, and they observed all of the same folklore that had led to Tymer Willingham's execution, and that was being used to prosecute Gerald Lewis. And there's a microphone at the scene that picked up one of the firefighters that they're putting it out, saying that we think that we just proved the defense's theory in this case, right? Because it was that evident. You saw the pour patterns, you saw the multiple points of entry, you saw all these things that had been, believed to be arson indicators, and they just weren't. So that one experiment, and then they dismissed the indictment against Gerald Lewis, and he was freed to go. That should have changed everything. But I write about some of the entrenched beliefs in forensics in the book. And then there were dozens of wrongful convictions that went on for decades after the science had, including Cameron Todd Willingham's, after the science had already been debunked, because it's so hard to change minds of people who have been taught a forensic technique by respected mentors, that's accepted in court as expert witness testimony, as scientific evidence, that there are textbooks written about it, that there are whole organizations devoted to it, that to come to understand that your life's work may have led to, many miscarriages of justice, and that it was just wrong. It's a very, very hard thing for we're all human, very hard to accept, and in many cases wasn't accepted and led to, additional wrongful convictions.
Yeah, we as humans have a hard time admitting that we're wrong as well. And although I'm not going to ask about this, I highly recommend folks pick this book up for numerous reasons, but especially to learn about Nancy Grace's ascent from high-profile prosecutor to television personality, built on the lies of supposed arson indicators as well. So the NAS ends up presenting their findings at the 61st Annual American Academy of Forensic Sciences meeting in Denver, Colorado in February of 2009. How did that go, Chris?
That was an earthquake. It's exactly what we've just been talking about. It's just like that rolled across, that's the annual gathering, the largest in the world, of forensic scientists from all over the world. Thousands and thousands of people attended every year. And for years, for decades, there had been no discussion of wrongful conviction. There had been no real concerns around reliability issues. There had been no, pointing to these exonerations that the Innocence Project were having on some of things like hair microscopy and bite marks, because there had been no outside scrutiny by mainstream science of forensic techniques that had been being used in courts for 100 years. So there was really suddenly this spotlight this very uncomfortable spotlight shined on all of the forensic experts that were gathered and around the country with law enforcement that had been using these, to bust bad guys for a long, long time, suddenly was thrown into doubt by, the most important scientific entity in the United States. It was just, it's still talked about today. Every single brief that I write at the Innocence Project discusses the NAS report. Every single forensic conference that I go to, the NAS report is always on a topic. It shows, it was, how much sunshine was needed, in the forensic community to really examine by disinterested scientists the scientific validity of these techniques. And that just had not happened in any kind of systemic way before. I compared it in the book to what was known as a courtroom report in medicine, right? Is that for centuries, their medicine had been very similar to the way forensics was, and that it was really based on what I quoted, known as eminence based, rather than evidence based, right? And so the most prominent practitioners in medicine, this was true in forensics, basically would do case reports, say, I treated my patient this way, I used leeches, I bled him out, the headache went away, therefore bleed your patients out with headaches, right? So that was like kind of that, a lot of, in medicine, a lot of it happened to be accurate. A lot of it wasn't accurate, but they didn't turn to evidence-based medical decision-making and really until the 80s. And after this, the Corcoran report was very similar to the NAS report in that it wasn't medical doctors that were examining all the medical literature. It was statisticians, it was other scientists to take a look at what were the bases for these diagnoses that the doctors were making. And a lot of them was very faulty. It wasn't evidence-based, right? And, more and more that is less and less true today. So it's very similar in forensics in the sense that there had never been this outside scrutiny. And it was a lot of mainstream scientists that had offered it, and that it was statisticians were part of that group. And the resistance was also very similar, and that medical doctors were rejected initially. The Corcoran report is people who didn't know what the hell they were talking about. So what is this statistician doing talking to me about how I'm treating my patients? Get out of here, right? What do you know, right? And that's the same in forensics, right? You could have Albert Einstein descend from, the clouds and come into criminal court and tell the judge, listen, judge, this bite mark stuff, it's junk, right? And the judge isn't going to listen to Albert Einstein, right? It's going to listen to the forensic odontologist, the board certified guy who's been doing this entire career. That's just the reality. And so when you have this outside scrutiny, it's incredibly significant and jarring.
Speaking of, why is Michael West an especially belligerent example of forensic odontology?
Michael West is a symptom of the disease of junk science, and probably the worst, offender in many ways, in that, when we started the strategic litigation department in 2012, bite marks had already, been shown to be grossly unreliable. The NAS report had happened. There had already been wrongful convictions. And my department was tasked with, amongst other types of litigation, with eliminating the use of bite mark evidence, and that we knew that it was that it led to wrongful convictions. We knew that there was no literature supporting it, and there had been some new research that tended to disprove some of the claim techniques. And so I had a notion, that because I was aware of Dr. West, because he was such a folk hero almost, right? And he was on the Phil Donahue show, he was on Vanity Fair. He was this guy from a dentist, so he called himself a little old dentist from Hattiesburg, right? And so he was from Hattiesburg, Mississippi. And he became kind of a folksy phenomenon. And that jurors just lapped it up, right? Because he was very charming and witty, and he would, a lot of all shucks, but also a lot of scientific jargon, enough to, this toxic mix of, plus, the credentials that the American Board of Forensic Odontology offered him. and jurors across the Southeast just loved it and wrongfully convicted a lot of people. And so I was added to a legal team that was litigating Eddie Lee Howard's case in Mississippi because I was becoming an expert in bite marks, and ended up, and I felt like, from the beginning of this work that, confrontation with Michael West was almost inevitable. And it was like that, like Luke has to confront Vader at some point, right? And that was like that moment for me. And I write about this deposition that I took with him where he was just totally out of his mind. He called me an asswipe under oath, and, it was just really, it would be funny if it wasn't a death sentence, that issue, and my client is in Parchment prison on death row. But it was really just an astonishing event in my life, in my career. And all the more so is that we lost. This madman, was like, testifying under, these like this bizarre theories, and so, it's really, it was one of the most significant, cases that I've ever been a part of, and really just a terrifying experience in many ways.
The guy strikes me as playing just a complete fucking character. I mean, he even got the costume to go along with it too.
Yeah, no, he's definitely fully in role, and seems like gleeful about, the role that he's played in miscarriages of justice, throughout, and he's totally unrepentant and stands by all of his opinions, right? There's he won't, admit to being wrong, except for the one time where he's actually caught in the act of matching a bite mark to a bite mark, or matching teeth to a bite mark that the teeth could not have created, right? There was an experiment done by Chris Blurred, who's now a judge in California, where he sent Michael West some teeth and photos of a bite mark. We knew it was actually to be a bite mark, but the dental mold was from his investigator. He lived in Utah, right? And so he paid him his $750 fee, and West matched that bite mark to, he said that the odds were astronomical that anybody else other than Chris Bullard's investigator could have made that mark, right? We played that video of that false positive, right? This wrongful match in court in front of the judge, Judge Lee Howard from Columbus, Mississippi, and still lost. You have evidence playing out in court of quackery. We still lost. So, it's hard not to be cynical.
Yeah, unfortunately, I think that goes a long ways in explaining the entire state of Mississippi there. All right, Chris, just a couple more questions. First off, what are unindicted co-ejaculator theories?
So this is an expression that became popular in the Innocence movement because it's an effort to explain away exculpatory DNA evidence, right? So Michael West, for example, had his own unindicted co-ejaculator theory for a wrongful conviction of Levon Brooks and Kennedy Brewer. In both cases, he claimed to have matched bite marks of those two men on these 2-year-old victims who had been raped and murdered and been kidnapped from their house and raped and murdered and bodies disposed of in a swamp in Mississippi. And he claimed that bite mark evidence matched both of those men to the bodies, to the exclusion of everybody else on the planet, and then that there were dozens of bite marks. And it turned out that there was one man that was responsible for both very, very similar crimes. He confessed to them. He confessed to everything except for he denied biting them, actually. And it turns out they weren't even bite marks. So when I questioned him about those cases during the deposition that we just talked about, he offered the theory, and he stood by it, that he didn't say that either of these men had committed the murders or the rapes. He'd only said that they'd bitten him. So his theory is that both men had held down in separate incidents, entirely unrelated, that they had sold these 2-year-old girls to the actual perpetrator in exchange for money or drugs, wasn't sure which, and that he had held them down and bit the victims while the perpetrator raped and murdered them. And so that's a kind of a classic unindicted co-ejaculator theory, right? And and you get, less extreme, examples all the time, where it seems like, very obvious that, there was one perpetrator, a rape, for example, where somebody knows how many people were there. And suddenly you'll just be claiming that there were two perpetrators for the first time ever, in an effort to explain it away. So it became such a common phrase that my colleague, Jackie McMurtry, who ran the Washington Innocence Project for 20 years, wrote a law review article called Unindicted Co-ejaculators. It was, common enough for the title of a law review article.
Oh, so ridiculous. All right, last question now, Chris. Who is Steven Mark Chaney, and why is his story so important to you?
Well, Mr. Chaney was my first Innocence Project client. He was wrongfully convicted by the Dallas District Attorney's Office in the 80s on a bite mark case. And he and I got close over the years. And when I decided to write the book, he was the person that I was interviewing the most about it. I wasn't doing that when I was actually representing him. And his struggle, which I draw the arc of the history of the Dallas District Attorney's Office through the struggle of his wrongful conviction and some of the progress that's been unique in Texas, kind of paradoxically, given the commitment to the death penalty that has also happened in Texas with the Forensic Science Commission and other progress. So Steven Chaney was a beautiful human being. I had great admiration and respect for him, and his story is really the backbone of the book. And so that's why, he's one of the people that I dedicated it to. And, he was really a victim of junk science in many ways, in all ways, really.
Yes, he was. Rest in peace. Chris Fabricant is the Innocence Project's Director of Strategic Litigation and one of the foremost experts on forensic sciences and the U.S. criminal justice system. That is the basis of his excellent new book, Junk Science and the American Criminal Justice System. You can get it now wherever books are sold. Chris, thank you so much for the time today, and thank you so much for this important book.
My pleasure. Thanks so much for having me on.
Thanks to Gentleman Jesus for the intro and outro music. Hear more of his work at gentlemanjesus.com. And thank you to Joshua Bates for the video editing. If you have any video editing needs, hit him up on Instagram at Forager Digital. And thanks as always to you for checking us out. You can watch, listen, learn, and connect for free at booksonpod.com. For Books on Pod, I'm Trey Elling. Good day.